Supreme Court today, where in a majority judgment, the Apex Court backed the pro-poor quota brought in by the centre through a constitutional amendment in Parliament. The centre had underlined Sabka, Saath when in fact bringing this amendment and talking about inclusive development, and the centre now claims vindication, saying that the courts upholding the amendment made to the Constitution in 2019 as consistent with the provisions of the Constitution is a big validation, of course, to the centre's decision and the amendment that had been introduced in Parliament to provide 10% additional quota for economic backward or members of the economically backward category. So therefore, the centre has once again emphasized that its amendment through the 103rd Amendment to the Constitution brought in 2019 in Parliament now stands vindicated on the part of the Supreme Court's majority decision. Remember that the Chief Justice of India, U.U. Lalit, along with Justice Ravindra Bhat, were in fact part of the dissenting judgment in a bench of 5. The two of them had given a minority dissenting opinion claiming that the amendment was unconstitutional and ought to be struck down, but they were prevailed upon by a majority opinion offered by 3 other judges who have decided to uphold the provision made in the 103rd Amendment as constitutional. Let me go across to Harish for more on this. Harish, it's a majority judgment 3-2 which has upheld the constitutional amendment made in 2019. However, there was a note of caution struck by at least 2 judges within that majority opinion as well. One is, of course, Justice Bela Trivedi, who talked about a timeline for the quota as well as reservations, and also Justice Pardiwala, who claimed that these kind of quota should not be misused by vested interests.
Yes, that's right, Siddharth. It's a big win for the centre, as the EWS quota has got the stamp of approval of the Supreme Court. In fact, it has been described as an affirmative action by the Parliament for the benefit of the economically weaker sections, and it has declared 103rd Constitutional Amendment for providing quota for economically weaker sections as valid and constitutional. EWS quota does not violate basic structures of the Constitution. It also says quota does not breach the 50% ceiling on reservation fixed in the 1992 Indira Sawhney judgment, that is famously known as Mandal Commission case, and economic criteria can also be a yardstick to provide reservation. This is very, very significant, Siddharth, because when Supreme Court says that not just social and other features, but economic condition of a person, economic status can also be considered as a yardstick to provide reservation. EWS quota does not disturb the 50% quota meant for the socially and economically backward classes, and the Supreme Court has said EWS quota will benefit poor of the general category, and EWS quota does not violate Article 14, that is equality before law, and Article 15, that is prohibition of discrimination on the basis of religion, race, caste, sex, or place of birth. But as you rightly said, this was a 3-2 verdict, because very significantly Chief Justice Lalit sided with Justice Ravindra Bhat, who had dissented. But the outcome is that it's a 3-2 majority judgment. So the centre's EWS quota has been upheld by the Supreme Court. Every argument of the centre had been upheld by the Supreme Court. Remember, centre had argued that reservation provided under it was different and had been given without disturbing the 50% quota meant for socially and economically backward classes. Centre had said the 10% reservation had not violated the basic structure of Constitution or Supreme Court ruling of 1992 in Indira Sawhney case, and justifying the quota, the Attorney General had argued that it was an attempt to benefit poor of general category who have been deprived so far, and government maintained that there is no 50% reservation limitation in Constitution. So all these arguments of the centre has been upheld by the Supreme Court, which in a 3-2 judgment has upheld the EWS quota.
Right. Many thanks for taking us through the details of that judgment. Harish, let me go across to Madhav Das Gopalakrishnan, who is joining us from the newsroom in Noida. For more on this, Madhav, the centre has welcomed the judgment that has been issued by the Supreme Court, a 3-2 majority opinion, and has claimed vindication.
Well, yes, the response of the centre is, of course, one that is welcoming, of course, of this particular judgment, because remember, it is a legislation that was brought in by the same government, and the centre has come out to say that the reservation has always been a very complicated subject in India's history. Due to reservation past, politically vested interest groups have created social fault lines and further division in society. Governments have also fallen over reservation. The memories of the Mandal Commission agitation, the agitations in many states are still fresh in the minds of many. Due to caste wars, lives have been lost, and there have been ugly caste massacres. In such a context, the Modi government took a historic decision to provide reservation to people belonging to economically weaker sections in 2019. This was brought in to promote social equality by providing equal opportunities in higher education and employment to those who've been excluded by virtue of their economic status. This decision was noteworthy because it not only gave benefits to certain class of people, but it also did not take away benefits from people. What the Modi government did was a break from the previous culture of discrimination and divisions, where to give something to one group, things were snatched from another group. When the EWS reservation came through, it was welcomed by people across castes and communities. At no point did SC/ST communities feel that their rights are being taken away, and this is the uniqueness of the decision that indicates the Prime Minister's way of approaching things. Also, Centre going on to say that likewise, for a country which has witnessed so much of caste wars and bloodshed, not a single incident of violence took place when this decision was taken, and it continues to happen even today. This shows the government's compassion for the people and its ability to take tough decisions and take them to the logical culmination. Today, no less than the highest court of the land, the Supreme Court, has given its consent to the EWS legislation. The majority view has held that the legislation does not violate the basic structure. Needless to say, the small vested interest group which thrives in social divisions is raking up non-issues. Also, very importantly, going on to say that it may be recorded that this is the same government which has fulfilled the most long-standing demand of an OBC commission to safeguard the interests of OBC communities. It is also this government that has toughened provisions of the SC/ST Act, thus ensuring dignity and protection to the marginalized. So, from the point of view of social justice, the government certainly, of course, welcoming this particular decision that had been taken by the court, and also, of course, the fact that this is the government that had pressed for such a reservation in the first place.
Many thanks for taking us through that, Madhav. The government, of course, emphasizing all the steps it's taken for the benefit of other backward classes, the scheduled castes and the scheduled tribes as well, in that statement that it's now issued while welcoming this judgment. We'll turn our focus now to the state of affairs in